Hello, everyone. Today's case is Nix v. Hedden. So this is about tomatoes and how they should be considered in light of tariffs. The court takes judicial notice of the ordinary meaning of all words in our tongue, and dictionaries are admitted, not as evidence, but only as aids to the memory and understanding of the court. Tomatoes are vegetables and not fruit within the meaning of the Tariff Act of March 3rd, 1883. This was an action brought February 4th, 1887, against the collector of the Port of New York to recover back duties paid under protest on tomatoes imported by the plaintiff from the West Indies in the spring of 1886, which the collector assessed under Schedule G provisions of the Tariff Act of March 3rd, 1883, imposing a duty on vegetables in their natural state or in salt or brine, not specially enumerated or provided for in this act. 10 per centum ad valorem, and which the plaintiff contended came within the clause in the free list of the same act. Fruits, green, ripe, or dried, not specially enumerated or provided for in this act. At the trial, the plaintiff's counsel, after reading in evidence definitions of the words fruit and vegetables from Webster's Dictionary, Worcester's Dictionary, and the Imperial Dictionary, called two witnesses who had been for 30 years in the business of selling fruits and vegetables, and asked them, after hearing these definitions, to say whether these words had any special meaning in trade or commerce, different from those read. One of the witnesses answered as follows: "Well, it does not classify all things there, but they are correct as far as they go. It does not take all kinds of fruit or vegetables. It takes a portion of them. I think the words fruit and vegetable have the same meaning in trade today that they had on March 1st, 1883. I understand that the term fruit is applied in trade only to such plants or parts of plants as contain the seeds. There are more vegetables than those in the enumeration given in Webster's Dictionary under the term vegetable, as cabbage, cauliflower, turnips, potatoes, peas, beans, and the like, probably covered by the words and the like." The other witness testified, "I don't think the term fruit or the term vegetables had in March 1883 and prior thereto any special meaning in trade and commerce in this country, different from that which I have read here from the dictionaries." The plaintiff's counsel then read in evidence from the same dictionaries the definitions of the word tomato. The defendant's counsel then read in evidence from Webster's Dictionary the definitions of the word pea, eggplant, cucumber, squash, and pepper. The plaintiff then read in evidence from Webster's and Worcester's dictionaries the definitions of potato, turnip, parsnip, cauliflower, cabbage, carrot, and bean. No other evidence was offered by either party. The court, upon the defendant's motion, directed a verdict for him, which was returned and judgment rendered thereon. The plaintiffs duly accepted to the instruction and sued out this writ of error. Mr. Justice Gray, after stating the case, delivered the opinion of the court. The single question in this case is whether tomatoes, considered as provisions, are to be classified as vegetables or as fruit within the meaning of the Tariff Act of 1883. The only witness called at the trial testified that neither vegetables nor fruit had any special meaning in trade or commerce, different from that given in the dictionaries, and that they had the same meaning in trade today that they had in March 1883. The passages cited from the dictionaries define the word fruit as the seed of plants or that part of plants which contains the seed, and especially the juicy, pulpy products of certain plants, covering and containing the seed. These definitions have no tendency to show that tomatoes are fruit as distinguished from vegetables, in common speech, or within the meaning of the Tariff Act. There being no evidence that the words fruit and vegetables have acquired any special meaning in trade or commerce, they must receive their ordinary meaning. Of that meaning, the court is bound to take judicial notice, as it does in regard to all words in our own tongue, and upon such a question, dictionaries are admitted, not as evidence, but only as aids to the memory and understanding of the court. Botanically speaking, tomatoes are the fruit of a vine, just as are cucumbers, squashes, beans, and peas. But in the common language of the people, whether sellers or consumers of provisions, all these are vegetables, which are grown in kitchen gardens, and which, whether eaten, cooked, or raw, are like potatoes, carrots, parsnips, turnips, beets, cauliflower, cabbage, celery, and lettuce, usually served at dinner in, with, or after the soup, fish, or meats, which constitute the principal part of the repast, and not, like fruits generally, as dessert. The attempts to class tomatoes with fruit is not unlike a recent attempt to class beans as seeds, of which Mr. Justice Bradley, speaking for this court, said, "We do not see why they should be classified as seeds, any more than walnuts should be so classified. Both are seeds in the language of botany or natural history, but not in commerce nor in common parlance. On the other hand, in speaking generally of provisions, beans may well be included under the term vegetables. As an article of food on our tables, whether baked or boiled, or forming the basis of soup, they are used as a vegetable, as well when ripe as when green. This is the principal use to which they are put. Beyond the common knowledge which we have on this subject, very little evidence is necessary or can be produced." Judgment affirmed. Well, that was a quick read. And as always, if there's any case you'd like me to read, just drop in the comments. I'd be happy to take a look. Thank you.